Hello, I'm Vince White. I'm an employment attorney. I apologize for being so casual. It's the day before Thanksgiving. It's November 25th, 2020. And I am answering a question posted publicly on avo.com where an individual was asking for answers from employment attorneys. Let's see here. Okay, I will read the question and then we'll provide an answer, and hopefully we're going to help this individual and be useful, and it'll be good. Okay, so the question reads as such: Is it possible to pay an attorney for a discovery analysis only and not retain them even if there is a case? It goes on. My case seems complicated. Every time I consult with an attorney, they tell me I have a different type of case, or at least one case of defense. At least one case of defense is better than the other. It sounds like one case is better than the other. I am not even sure at this point what kind of case I have, but it seems there's definitely something there. However, since I am unable to establish the type of case myself, I cannot decide if I want to move forward with a lawsuit. That is difficult. I certainly commiserate with that. It's an employment case, and I'm not ready to lose my job over this, as it's very hard to find a job during the pandemic. True. My goal is to attain a settlement and remain at the company. However, depending on how the case will be argued, I do not know if that is even possible. I will need an attorney to assess this case, as I am not qualified. How much does an attorney charge just to perform the discovery process? Okay, so I can answer that. And I think, I'm not sure, but I think when you're saying discovery process, what you actually mean is a case analysis, which means really digging into the documents, looking at what the witnesses are probably going to say, your testimony, really getting taking everything and getting it in their head, digesting it, and saying, okay, this is a potentially valuable case that I think could win, and I want to help you. Or listen, it's a case, but I'm not sure I can win it, and it's a lot of risk, right? That there's a whole spectrum. They might just come back and say, listen, I don't think you have a claim, right? It doesn't sound like that's going to be true here. It sounds like every attorney you've spoken to thinks you do have a case. Some, though, are saying the case is stronger than others, right? So that's very confusing for you. So yes. So I think most firms would be happy to do that for you. We certainly do that process for free, but we do it without going page by page through the documents. So if you're looking for us to read thousands of pages, lots of documents, really dig into it, and give you a formal opinion as to whether or not we think you have a claim that is potentially valuable and could win, yeah, we could work something out. That's not a problem. I think most firms would be fine with that kind of deal. Now, that's what I'm assuming you mean when you say discovery analysis. I'm guessing you might actually mean a case analysis. But if you mean discovery analysis, if you mean you want them to engage in the discovery process for you, meaning you want to have a case filed, not have an attorney, but have the attorney draft your discovery demands and get the discovery responses from the other side and digest them and look at them, and after that discovery process say what they think about it, you may have a hard time finding an attorney to do that. I mean, you could probably work out an hourly rate. The problem is, if they work on the case, if a law firm works on your case while you're pro se, judges don't really like having pro se cases before them, in my experience. And often they'll try to rope any attorney anywhere near the case in as your counsel. So you might work out a deal with some attorneys to handle the discovery for you, and they run the risk of, one, something goes wrong and they didn't advise you about it because it's not what you hired them for. Maybe they're on the hook for malpractice. Even though they weren't hired to handle that part of the case, wouldn't be the first time somebody tried that, right? Two, judge, maybe you're at a conference, you tell the judge, oh, my counsel that I hired for discovery did this, and here you go. And the judge is going to say, counsel that you hired for discovery, get him in here. I want him on the case. Can the judge do that? Not technically. but it's real hard to say no to a judge you have to practice in front of for the rest of your career, right? So it's a bit of a risk. I'm sure you could probably work something out. It's always going to be devil's in the details. You got to really hammer out the arrangement. But I really don't think that's what you're asking. I think you're actually asking for like an in-depth case analysis where people really dig into the documents, really go through the potential testimony, and give you an in-depth response of their thoughts on the case. And yes, that would certainly be available. And I think it's actually really responsible that you're going that route. And you're also probably going to want a memo on whether or not your potential claims are going to lock in protections against retaliation. Because if your main goal is to get a settlement but stay at the job, well, one of the best ways to achieve that is if you have a claim that locks in protections against retaliation for you, because then you'll have this huge protection in the workplace, and anything negative done to you from that moment on, once you engage in protected activity, anything negative done to you gives rise to a new claim. So the employer will at least be afraid to mess with you, which skyrockets your chance of keeping your job, right? I really hope this was helpful. I'm sorry that you're having conflicting answers from attorneys, but I think people should be happy to do this analysis for you, certainly.